Thank you for joining us on Law and You this wonderful Monday. I'm Uyag Mofwegwe. We are in Benin City, Nigeria. This week on the program, we want to look at court judgments. The fact that in a number of cases we have instances where there are conflicts in court judgments. In the same matter, for example, you find 2, 3 judgments. In several instances, these judgments are loggerheads with themselves. And then you see lawyers trying to interpret these verdicts from time to time, and becomes more complicated for the everyday Nigerian, especially non-lawyers, to understand. So that naturally kicks the question of what are the factors that give rise to conflicting court judgments? Could it be a matter of jurisdiction? Could it be the facts of the case? Could it be other legal dynamics that the non-lawyers probably don't understand? And then ultimately, what are the implications for the legal system? Does it strengthen the confidence of the public in the judiciary? These are the issues we want to look at on the program this week. After this break, you'll meet my guest. I'm joined by Dr. Patrick Awosaige. He's a legal practitioner. He's here to help us understand some of these very deep issues. It's always a pleasure to have you come.
Thank you very much.
Talk to us here on Law and You.
Yeah, and thanks for having me.
I want us to look at. I'm very sure you have had several judgments on behalf of your clients, for example.
Yes.
I'm also thinking many of them probably have not been in conflicts, basically. But how does it feel for you as a practicing lawyer?
Yes.
When you watch television, for example, time and again, and you're seeing conflicts in court judgments, what impression do you take away?
Thank you very much. When you say conflicts, I think from the beginning, there's already a conflicting issue. Hence, you are in court. The other parties and these parties, party A and B, have 2 lawyers.
Disagreement.
So there's already a conflict. So they are trying to find a meeting point to decide conflict that's on ground. That's where you call your lawyers. Look at this, look at that. You give your lawyer, you brief your lawyer, and the other party brief his lawyer. And then you go to court. And then the court looks at it, and the facts of the case, will be presented before court. We call pleadings now. You tell court what you are bringing before court, and when all these pleadings are argued in court, the court decide on what to agree on based on what the principle of law is. Many a times we use our emotions and sentiments to play around. Oh, he's a little boy, or she's a woman, why would they should have considered her, and all of that. Now,
the law doesn't respect those factors.
It doesn't respect those factors. So, or maybe, oh, I didn't know. I remember there was a particular gubernatorial candidate who actually was contending with the then governor, and he got to Supreme Court, and he was bringing the issue of certificates. And then the court now said, you are the Supreme Court now. And the court is not a Father Christmas to start giving you what you did not send to us. We cannot help your case in that manner. So in that sense, the court was dismissed and thrown out of the court. So people will say, why will the court not look at that? Why will the court act this way? The court should know. No, your court will only restrict itself to what is before it. Now, for instance, let me give an instance. I've known you for quite some time. And now somebody is saying, Uyi is a doctor. And I'm the judge now. I've known you have never been a doctor.
Right.
And if the facts on ground is that you are a doctor, and I'm looking at that, I won't say because I feel you are something else, or I've known you for 20 years. That is
immaterial now.
Immaterial to what is before court. So I think that's where a lot of people get it wrong. Forgetting they should also tax their lawyers. Most of the time, the lawyers will overlook certain things and would not want to know. I'm not saying they are not doing their jobs. I don't know who. There's always, if there are no grounds for lawyers to neglect their duty or jobs, the court would not have been funding, or rather finding some of our colleagues for their matters filed for want of diligent prosecution. If you are not diligent in prosecuting your matter, you could lose your case. And if there are things you ordinarily should do and you didn't do it, it could amount to you not doing well. and at the end you start raising dust. You don't win cases on the streets or in the court environment or ranting around. You go back. We have been told that you win your case in your chambers. You have to read through, you have to do your case properly. And again, I must quickly bring this in. There's this issue, maybe we have a judgment now. Okay, let me give a Segun Oni and what's his name again? The former governor of Ekiti State. So, Fayemi, at the first time he came in as governor, you know he's governor now. I mean, when he was governor then.
Yes, first term.
First term. Then Fayemi, Segun Oni was seeking a second term. Fayemi was coming in as you know, in the first term, and he won that election under the platform of the APC. And Fayemi won the election. Segun Oni went to court to say Fayemi did not resign properly from where he was working. So on that ground alone, he should be deprived or denied. He should be the governor. And he had a very strong case.
That was his prayer.
That was his prayer. He had a strong case. And then he went on and on to Supreme Court. When we got to Supreme Court eventually, and the Supreme Court justices were so sorry that the matter got to them over the stipulated time. So it became statute bar. So there was nothing the Supreme Court could do at that instance. You have a good case, but time, by the effusion of time.
The window had closed.
So Fayemi was governor. So these are some of the issues that we find. Now again, why did they now make it 180 days? You remember there was one Peter Obi, and there was one Adams Oshomole, who became governor after some time, maybe a year or thereabouts, into 2 years for the former governor, Professor Sarima Osumbo, who, his case was even good. I'm talking of Chris Ngige and Peter Obi.
In Anambra State.
In Anambra State. Chris Ngige was governor for almost 4 years. Peter Obi was fighting for almost 4 years to become governor, and they eventually won. And then one Andiumba came up, went to court because the constitution is there that, you know, after 4 years, somebody else can come in to seek election, like we are having today now in Edo State. Now, then he now went back to court and said, my lord, I've only be governor for 6 months. How can I so be in power for 4 years? It's a 4 years term. And then he changed the narrative. Then the man that won, who was claimed to have won the said election then, that he challenged, that was Andumba. And he was now said, no, you have not finished your term. So that election ordinarily would not have bet. That's it. So this is the beauty of law. And when that happened, so he came back and he became. But again, there was need to review the Electoral Act. How can somebody be fighting in court for the whole term of, you know, of the governor
of an entire administration,
so to speak? It doesn't make any sense. So there was a review. Let's narrow it down to 180 days. And you can see now it was narrowed down.
It's an improvement.
An improvement. Okay, let us make it 180 days. What happened? Justice was also, you know, denied of sort because of time. You can see Segun Oni. So either way, we try the best way that it will better the lot of the people. You can't always get it right because we don't live in a perfect system. And we are not God. And but we must assure the people that we don't have option. Like I keep telling people, if a doctor calls you, I keep using the doctors and say this is what you should do. You won't argue with him whether he is doing the right thing or the doctor that treated you before. The current doctor is the one you listen to. Now, if you look at these examples I've cited now, you will not blame the Goodluck Jonathan's administration that said let's have an electoral review to bring it down to 180 days so that we will not have a repeated episodes of the likes of Peter Obi that have stayed there. You know, I mean, Chris Ngige, who was not governor, who was eventually thrown out as governor, but has succeeded in being governor for almost 4 years. So let's narrow it down. And there's issue of pre-election matters that should end before time. So these are the many issues. And these are applications, and mind you, they are all tied to principles and time. Now, if you are coming to court, there are certain time to file certain processes. And then the judges and justices, as the case may be, we have to look through your application. They don't just pick it and say, well, this one is not good. They don't do that. They have to read through, and they will come out with their findings, and then they will give to you. Now, you talk about conflicting judgments. I can remember of the, several court judgments, like maybe one from a particular court, and the issue of jurisdiction, you mentioned it. Right. You've already started answering. When you have, no matter what it is, anytime the issue of jurisdiction, even before judgment, you can raise the issue of jurisdiction. And it will hope. Look at what happened to somebody like Senator Ojius Okalu. You know, he was already convicted.
Yes. And
then he was even in the prison.
Serving his time.
Serving his time. You know, a case that was preferred back 12 years ago. Now he was to serve his term in prison. Then his lawyers had gone back to court. I said, there is something wrong somewhere. What is it? They said the judge that made the pronouncement
had been elevated.
You cannot be a sergeant, and when you are promoted an inspector, to resume a different office, still remain in that office, when your ordinary should be dropping your handover notes and leaving it there for your new incoming sergeant to take over. You remain there. He was the same judge. Then what is your own matter in this? That in itself is injustice. The law frowns at that, and on that ground alone, the whole process was set aside to start the novel, to go all over again. And that is where we are. And the man is in the Senate chambers because of that singular act. So you can say it's as sensitive as that, because when you are talking of criminal prosecution, now you know there's a criminal prosecution, there's a civil prosecution, civil actions in court. Now when you are talking of the criminal prosecution now, it's beyond all reasonable doubts. So if there is doubts on the minds of the judges,
no matter how
small, but as I said, but you can see now, they saw him in the room, he is the one that committed it. Why? You have been unable, even in the medical expert report in court, I have not convinced even the judges. They will throw it out. And people will raise alarm and say, well, the courts have been bought over. It's not correct.
You have mentioned a number of factors now, but let's talk about this particular one, which has to do with jurisdiction.
Absolutely.
Where there's a problem of jurisdiction in the middle of a matter.
Yes.
Essentially, who takes responsibility? Is it the counsel? Or whose responsibility is it? Because a lot of non-lawyers will say, didn't these lawyers, as professional as they are, being practicing lawyers, know that this was a problem of jurisdiction from the very beginning? How come the case would have gone up to a certain point, run for maybe a few months, sometimes for a couple of years, before somebody suddenly realizes that there's an issue of jurisdiction?
Now, see, you verily, I agree with what you are saying to an extent, not in its entirety.
Okay.
There are cases like that. There are matters that could have, coordinate jurisdiction, like maybe a court here and a court there. Now, there are also instances that some persons, it's just how you see it. It may necessarily not be that maybe he doesn't know, he should know. Yes, I know that if you must institute, there are certain actions that will not start in certain courts.
Right.
You know, there are certain matters that you should be in a particular place, and the rules could change also. Rules of courts. It's not
from time to time.
Oh yes, oh yes.
Okay.
The civil procedural rules of the Edo State judiciary now has also been reviewed over time.
Does it mean there are instances, for example, where some of these lawyers do not understand the current practice direction? Is that also possible?
You cannot. You have to keep the law is will be guided by the dictates
every step of the way.
Oh yes. So it's possible. It's possible, but I think that would be very, 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 very funny on the part of anyone. Yes. Because if you are, the lawyer is not to know all, is to know where to find the laws. That is the training. The lawyer is not to know all the law. It's even Lord Denny, renowned jurist, that said, if it be that anyone will claim he knows the law, you cannot know all there is. All you should know is to know where to find what you are looking for. So what will a lawyer do? When you are going on with a matter, you should go find out. And you should know if this is what it is. But the issue of jurisdiction can be raised at any time. It can be, yes, you say, well, who do we blame now? Do we blame the court? Okay, the court, if the opponent come up to say, and there are cases that the court could have that jurisdiction. You see, the scenarios are not the same. That's what we should understand.
Okay.
So there are certain scenarios that play out. A jurisdiction here may be, you may have jurisdiction here. And it's when the court looks at it, when they know this, raise an issue of jurisdiction is raised in court, it will be lost on the court to check through and give a ruling on it. The court will now have to look at it based on what you have supplied and compare it with what the rule says. And the court will now decide and say, well, we have jurisdiction or not. If the court says we do, then the matter goes on. Okay. Then even if you still don't agree, you can still appeal that even to the Supreme Court. So you
challenge
can challenge jurisdiction. Yes, you can still challenge it. So it all depends on what finally turns out to be. You know, the good thing about the principles and the procedure is that you can always come back. You can always go up and make, you know, your complaints and, you know, like in the appeals. You could appeal it even to the Supreme Court.
Okay, we're going to take a quick break now. We'll just have a few more other elements in this discussion. We want to quickly x-ray before we're done with the program for this week. We're back shortly. Stay with us.
Opening 86th birthday program of events. The House of Ignacio announces the program of events to mark the 86th birthday of their patriarch, the Honorary Romanian Consul to Edo and that state of Nigeria, His Excellency Sir Chief Dr. Gabriel Usawa Ignacio CFR. The ESMA opening tagged "I am my brother's keeper." Due to the COVID-19 pandemic, the celebration of the 86th birthday has been reviewed in line with the standard NCDC COVID-19 protocols. Day 1, Friday 11th September 2020, the D-Day, 11 a.m. virtual church service to be streamed live on all ITV channels, Facebook and on Zoom to enable the world participate. Day 2, September 12th 2020, 2 p.m. to 6 p.m. 86th birthday family lunch. Day 3, September 13th 2020, 86th birthday Thanksgiving at God's Historic Church. If it wasn't for the Lord, where would we have been? This explains why this year's celebration is very unique, as we appreciate God for His love, mercies, faithfulness, and divine protection. This announcement is signed by Her Excellency Lady Cherry Igbenegio for the House of Igbenegio.
I was going to ask you something about still jurisdiction and these perceived conflicts. Okay. In the case of Edo State, for example, because you had several interests,
yes,
we saw cases flying as far as Kano, Port Harcourt, for example, in some instances, Ekboma. And then there wasn't really convergence ultimately. It will appear that there was this inconsistency in all of these verdicts. So what are some of the circumstances that give rise to this kind of?
Now, for that, you see, when a matter is decided by a court,
yes,
for you to appeal that judgment or ruling, you must go to the appeal court. Now, in the area customary court, for instance, you know, let's say the magistrate court now, the appeals go to the high court. Maybe in the magistrate court where we have issues there, and then when judgment is entered and whatever, you are not comfortable with that, you go to the appeal court.
All right.
Now, in the area customary court, maybe you have a matter there, and then it is decided, for me to act, I'm not comfortable with this. What do? I make my appeals to the high court. So the high court will now sit on appeal on what happened there. That's the way it runs. Now, in a situation whereby I have a matter at the High Court in Benin, and the judgment was entered, and I rushed to Kano High Court, you know, to set it aside. That is abuse of court processes, because that court and the court in Benin, they are courts of coordinate jurisdiction. They are at the same level.
So there was never need to take it all the way to...
It's about Einstein that said a problem that is solved, that is created in a particular level, cannot be solved at that same level. You need to go a step higher.
Escalated.
Yes, to solving it. It's a simple principle. So commonsensical, you should know that you cannot do that. But most of the time, such applications are done not in bad faith, just to buy time and to make an impression, not necessarily to get judgment, as it were. Not that, it could just be a way to distract the populace and
certain interest.
You understand, to create an impression that we are doing something. I think that is what that is for. I don't think there is any lawyer that don't understand this very, very infinitesimal principle of law, that a court of coordinate jurisdiction cannot really hold anything. When you find a judge ruling, and the judge will tell you, well, all the DSS and police that have been withdrawn have also restored it back based on the facts before me, because it's the prayer that you have tendered to court. So this is wrong, and I think it shouldn't be encouraged. And I think it should be encouraged, because if a lawyer is briefed in that sense to do that, and you engage in that, it's wrong practice.
Let's talk about something else. The impression most people have from my interaction is that the law is very protracted, the law is very complicated. Is that the case?
When you say complicated, we live in a complicated world. I don't think
so. So the law is no exception. Is that the point?
You know what I'm trying to say? When you say complicated, we live, even at home in your house, there are a lot of issues around.
But that's relative.
I'm trying to, I agree with you. What I'm trying to say, when we use the word complicated, look like something that cannot
complex.
Yes, it should be complex. It should be. If it's not complex, then there's no way we could attend to a lot of the complications around society. There are a lot of things that we do, and there are a lot of things we see that you have to know and go here. So in trying to find a bearing to all of this, that's what people are saying and say, this, we are tired. It's not like that, because the law have to roll through, and the preponderance of balance have to swing through, and we need to know exactly where we are to get the right judgment. I think that is basically it. I don't want to, that word complicated. I think I want to say it more on the negative sense. But if it's from the positive sense, I think I will embrace that.
But just before we're done, there's the notion that politicians, because of the for the most part, the enormity of wealth and clout that they have, are able to influence outcomes of cases in courts. Of course, that remains to be substantiated. But the notion is that politicians, to a large extent, are able to swing, or if you like, influence cases. So to the point that you now begin to have these perceived conflicts that we've been talking about for over 20 minutes. Have you seen any semblance of that?
In fairness, I disagree with that. Now, if you say maybe, you should be able to point out
certain instances.
Now, if you are saying politicians are influencing, yes, they could have friends among, judges and lawyers that are your friends. Even the president the other time gave money to his friend. If that doesn't have any to do, and somebody say, oh, why will you send a gift to a friend? It's normal. Now, the point I'm making here is this. If you can, because he that has sat must prove.
Right.
If you say a judge had obtained judgment because he was giving money, then you should be able to prove it. You should be able. Even if you don't have, okay, then legally you should be able to prove it. That the judgment delivered by this judge, based on this factor or what you are seeing, ordinary should not be. Then tell us what should be. If you don't have, well, you are just granting and talking around that he may have collected, it doesn't add up anything there. Now, the point I'm making here is this. If I know the rules and I've played by the rules, and if I'm even called in the Judicial Council to come and explain myself, why did you do this? And then I'm able to explain, and then that's fine. But in the event that I'm unable to explain, I think there was a man that actually the pension fund saga, the judge made of 32 billion thereabout, and then his judgment was that he should go and pay some
750,000. That was the main case, I guess.
You remember? And you could see the NJC frowned at that. And the judge was queried, and he was called in. This is wrong. So that was glaring.
Was that solution, was that intervention rather, was it far-reaching enough?
See, he will have to defend himself. For you to be saddled with this responsibility, how did you arrive at this? So you should convince us. If we are not, then you can be disciplined too. That you are a judge does not mean you cannot be called to order. You could be dismissed, you could be even prosecuted. We saw the CJN being prosecuted the other time. So if the Chief Justice of the Federation, in the person of Onoge, was prosecuted and was taken to court for all those allegations against him, that he was in court. So what we are saying is that there's nobody that is immune against being investigated and prosecuted, as it were, no matter the office you occupy. But I'm trying to say that that general notion, it's absolutely not correct. I disagree with that, but there could be a couple of persons.
But overall,
yes,
it's
the system,
unfounded.
yes, no. Nobody, the system does not encourage that, and nobody does encourage that.
Okay, I think this is a fine place at which we're leaving this discussion, this wonderful Monday. Thank you so much.
It's my pleasure
for coming on the program.
It's always my pleasure.
I've been speaking with Dr. Patrick Awosage, brilliant legal practitioner based here in Benin City. That's it for our program this week. Thank you for spending part of your day to watch as well. We're back here next week Monday with a different discussion altogether. I'm Uyi Agmofwegwe. Our coverage here on ITV continues. Have a great evening ahead of you.